Welcome to the Deep Dive. Today we're tackling a really fundamental tension in any democracy. National security versus individual liberty, especially, in times of crisis.
Right. How far can the government go? What's the cost?
Exactly. And that leads us straight into our core question for this deep dive. Should a U.S. citizen, someone labeled an enemy combatant, actually get to challenge that detention in front of a judge?
It sounds academic, maybe, but it's incredibly real. It touches on who we are.
It really does.
Mm-hmm.
So for this, we're drawing on excerpts from an academic text looking at law and terrorism. We'll be focusing specifically on the big one, Hamdi v. Rumsfeld, the 2004 Supreme Court case.
And we'll dig into both sides, Justice O'Connor's majority opinion and Justice Thomas's dissent. Really see the clash there.
Our goal here is to give you a solid understanding of this case, habeas corpus, the whole enemy combatant idea, and these differing views. It's a shortcut, really, to getting informed on a vital issue.
It's a fantastic case study for how the legal system tries to balance these huge competing forces, especially under pressure.
Absolutely. And the backdrop, the catalyst for all this was, of course, September 11th, 2001.
Mm-hmm. The deadliest foreign attack on U.S. soil. Around 3,000 lives lost.
And our sources highlight not just the immediate shock, but the long-term effects, human, legal, and economic. Effects we're arguably still feeling.
And the reaction in Washington, very swift.
Yeah.
President Bush moved fast on retaliation.
And Congress?
Congress passed the Authorization for Use of Military Force, the AUMF, with huge bipartisan support.
Right, the AUMF. And it was broad, wasn't it?
Incredibly broad. It basically said the president could use all necessary and appropriate force against, well, anyone he determined was involved in the attacks. Nations, organizations, persons.
Okay, so that authorization is key. How did the Bush administration then use that to justify holding people as enemy combatants indefinitely?
Well, that's where the term enemy combatant comes in. The administration claimed this authority under the AUMF. Now, the definition has sort of shifted over time, but in Hamdi specifically, it meant someone who was, and I'm quoting here, part of or supporting forces hostile to the United States or coalition partners in Afghanistan, and who engaged in an armed conflict against the United States there.
So tied to the conflict in Afghanistan for Hamdi's case.
Exactly. But still, it granted immense power to detain without, the usual criminal charges or trial process.
And it's interesting you mentioned the definition shifted. The Obama administration stopped using the phrase enemy combatant officially back in 2009.
They did.
But the term itself, it hasn't really gone away, has it? You still hear it in political discussions, sometimes calls to apply it even domestically.
Absolutely. It's stuck in the lexicon. The language might change, but the fundamental debate about detention powers, that persists.
So let's put a face on this. Yasser Isam Hamdi, a U.S. citizen.
Right. Captured in Afghanistan late 2001 by Northern Alliance forces, then handed over to the U.S. military.
And then designated an enemy combatant by the president.
Yeah.
Held for, what was it, over a year? Without seeing a lawyer?
Over a year. Which led his father, acting as his next friend, to file that crucial petition for a writ of habeas corpus.
Okay, habeas corpus. Let's unpack that a bit. It sounds formal, but it's fundamental, isn't it?
Absolutely fundamental. You could say it's the fundamental right when it comes to detention. It basically means show the body the government has to justify to a court why it's holding someone.
So it's a check on power to prevent people from just disappearing.
Exactly. It goes way back, English law origins, baked right into our Constitution. And our sources stress, in Hamdi, the government wasn't saying habeas was suspended.
Okay. So they weren't invoking that emergency power like Lincoln did.
No. Their argument was different, more like it didn't apply in the same way to an enemy combatant captured on a foreign battlefield, even a citizen.
That brings us to some historical parallels. You mentioned Lincoln ex parte Milligan, 1866. That was during the Civil War, right? Lincoln had suspended habeas.
He had. And Milligan, a civilian, was tried and sentenced to death by a military commission, not a regular court.
But the Supreme Court stepped in.
They did, after the war. They overturned Milligan's conviction, said flat out. Civilians get tried by civilian courts with juries if those courts are open, even in wartime.
And there's that great quote from Justice Davis. Something about the temper of the times.
Yes, fantastic quote. During the late Wicked Rebellion, the temper of the times did not allow that calmness and deliberation and discussion so necessary to a correct conclusion of a purely judicial question. Basically, a warning against letting panic override due process.
A powerful warning.
Okay.
But then, fast forward to World War II, and you have Combatants of the United States, 1944.
A very different outcome.
Yeah. The court upheld the forced internment of Japanese-American citizens, innocent people. The reasoning was deference to the military in a time of national emergency.
The deference, yes. But it wasn't unanimous. It's crucial to remember that. 3 justices wrote really stinging dissents. They called it out as racism, a violation of rights.
And Korematsu, though never formally overturned by the court, has been widely repudiated since.
Right. Thoroughly repudiated. There was a congressional commission in the 80s that found it was driven by fear, prejudice, wartime hysteria, not actual military necessity. President Clinton formally apologized. Fred Korematsu got the Medal of Freedom.
So you have Milligan saying courts must protect rights even in war, and Korematsu showing the court deferring, tragically wrongly. These cases really set the stage for Hamdi, don't they? They frame that tension perfectly.
They absolutely do. They're the historical bookends, in a way. They show the court wrestling with this role, sometimes getting it right, sometimes tragically wrong. Hamdi forced them to confront that legacy again.
Okay, so let's trace Hamdi's case through the lower courts before it hit the Supreme Court. It went to a federal district court first.
Yes, and District Judge Robert Dumar was quite skeptical of the government's case. He basically said their evidence for Hamdi's capture was little more than their say-so.
Strong words.
Very. He insisted that if the court just accepted the government's word without question, it would be acting as little more than a rubber stamp. He saw a real judicial role there.
But the appeals court disagreed.
Sharply. The Fourth Circuit Court of Appeals, Judge J. Harvey Wilkinson writing, took the opposite view. They argued for limited judicial review in wartime.
Why? On what grounds?
Primarily separation of powers concerns. They felt courts shouldn't intrude on the war-making powers of the president and Congress. Judge Wilkinson famously wrote that the usual safeguards of criminal trials do not translate neatly to the arena of armed conflict.
So basically, different rules apply in war.
That was their conclusion. They denied any further look into the facts behind Hamdi's enemy combatant label.
Okay, so a district judge saying, show me the proof, and an appeals court saying, not our place to ask in wartime. That sets up a perfect conflict for the Supreme Court.
Exactly. The fundamental question landed squarely in their lap. Can a U.S. citizen labeled an enemy combatant challenge that label in court?
Let's dive into the Supreme Court's thinking. Justice O'Connor wrote the main opinion, the majority opinion. She landed on the yes side, but with nuances, right?
Very much so. First, she acknowledged the government's point, up to a point. She agreed the AUMF did authorize the president to detain enemy combatants captured in the conflict, like Hamdi. She called detention a fundamental and accepted incident to war.
Okay, so detention authorized.
But, and this is the crucial part, she said, due process demands that a citizen held in the United States as an enemy combatant be given a meaningful opportunity to contest the factual basis for that detention before a neutral decision maker.
A meaningful opportunity. What did that mean, practically?
It meant Hamdi couldn't just be held on the government's say-so indefinitely. She really emphasized his liberty interest, calling it the most elemental of liberty interests.
And she had that line, liberty is the norm.
And detention without trial is the carefully limited exception, yes. She also highlighted the very real risk of error, the danger of locking up the wrong person. An unchecked system, she warned, could become a tool for oppression and abuse.
Powerful stuff.
Yeah.
How did she handle the government's argument about separation of powers, that courts should stay out of military decisions?
She rejected it pretty firmly. Her famous line there, "A state of war is not a blank check for the president." She insisted all 3 branches have a role, especially when liberty is at stake.
So what process did she say was due? Did Hamdi get a full criminal trial?
No, she acknowledged that full trial procedures might be too difficult or dangerous in this context. But she said the core elements were necessary. The detainee must get notice of the factual basis for being held and a fair opportunity to rebut the government's factual assertions before a neutral decision maker.
A neutral decision maker. Not necessarily a standard court, but someone impartial.
Right. She believed basic review wouldn't unduly threaten military operations, and that those concerns couldn't trump a citizen's core rights.
And she was worried about indefinite detention, too, wasn't she? Because this war on terror didn't look like traditional wars with clear endings.
Exactly. She noted the conflict's underpinnings were broad and malleable. If it never formally ended, Hamdi's detention could last the rest of his life. That possibility really underscored the need for some kind of check.
Okay, so that's the majority view. Detention authorized, but due process requires a chance to challenge the facts before a neutral body. Now, Justice Thomas, he had a very different take in his dissent. the no side.
Completely different. Justice Thomas's view was rooted in strong deference to the executive branch in wartime.
How so?
He argued that since the president, with Congress's okay via the AUMF, determined Hamdi was an enemy combatant, that decision fell squarely within the federal government's war powers, period.
And the court's role.
Minimal to none. He felt the court lacked the expertise, the information, the constitutional role to second-guess that decision. For him, protecting national security was the most compelling government interest.
No governmental interest is more compelling than the security of the nation. It's a direct quote, right?
It is. He believed the founders intentionally gave the president the primary power and responsibility for national security. He talked about the advantages of the unitary executive.
The idea that one person can act decisively?
Right.
Decision, activities, secrecy, and dispatch, as he quoted from the Federalist Papers. Things courts, by their nature, aren't built for, especially in foreign affairs and war.
And he cited Justice Jackson, too, about courts lacking information.
Yes, arguing these are political, not judicial questions involving large elements of prophecy, basically leave war decisions to the branches designed for them. Judicial intrusion is inappropriate and potentially dangerous.
So how did he view O'Connor's balancing test, the Matthews v. Eldridge test she used?
He strongly disagreed with using it at all in this context. He found it fundamentally inappropriate.
Why?
Because Matthews was originally about procedural fairness for losing government benefits property, essentially. Thomas argued you simply cannot balance the government's core war powers against individual liberty using a test designed for Social Security payments.
So apples and oranges, in his view.
Completely. He said, I do not think that the federal government's war powers can be balanced away by this court. He even pointed out, kind of wryly, that neither Hamdi nor the government had even argued based on Matthews. Interesting. So his conclusion, Hamdi got all the process he was due simply by being detained under the president's war powers, authorized by Congress.
That was exactly his position. The detention was lawful, end of story. No further judicial process was required by the Constitution in these circumstances.
Wow. Two really starkly different views of the Constitution in wartime. But our sources mentioned there was some common ground, surprisingly.
A little, yes. All the justices agreed the president is the one charged with making detention decisions in wartime as commander-in-chief.
Okay.
And they also agreed it is ultimately the judicial branch's job to say whether a detention is lawful or not.
So agreement on the basic roles, but total disagreement on how the judiciary should exercise that role in this specific context.
Precisely. The fight was over the method of judicial review. Is it the deep dive, balancing approach of O'Connor, or the highly deferential approach of Thomas? And that Matthews test was right at the center of that disagreement.
Which brings us back to those big questions our sources raise for you, the listener. In a time of war, how do democracies negotiate this balance? Security versus liberty.
And the other one, if wars like the one against al-Qaeda don't have clear end dates, can enemy combatants be held forever? These aren't just historical questions.
No, they feel very current.
Yeah.
So what happened after the Hamdi ruling? Did the administration set up that process O'Connor called for?
Sort of. The Bush administration created something called Combatant Status Review Tribunals, CSRTs.
CSRTs, okay.
What were they? They were military tribunals designed to determine if detainees held at places like Guantanamo Bay were, in fact, enemy combatants. It was an attempt to provide some process, arguably in response to Hamdi, maybe to try and head off future habeas lawsuits in federal court.
Like an alternative system.
Exactly, an alternative due process procedure, as they put it.
But did the Supreme Court accept that as sufficient?
Ultimately, no. A few years later, in 2008, in Boumediene v. Bush, the court ruled that the CSRTs and the law creating them were inadequate substitutions for the writ of habeas corpus.
Ah, so the courthouse door remained open.
Yes. The court reaffirmed that detainees still had the right to seek habeas corpus review in federal court. You couldn't just replace that fundamental constitutional right with a military tribunal system that lacked, in the court's view, sufficient procedural safeguards.
So even though enemy combatant isn't the official term anymore, the core issues from Hamdi, presidential power, judicial review, citizen rights, in wartime, they're still very much alive.
Absolutely. The labels change, the specific conflicts evolve, but that fundamental tension Hamdi exposed is enduring.
Well, this deep dive into Hamdi v. Rumsfeld really lays bare the incredibly tough choices we face about what we expect the law to do, especially when security and liberty seem to be pulling in opposite directions.
It shows how the Constitution provides the framework, but its meaning in crisis is constantly debated and shaped, particularly by the courts.
And it leaves us with this thought. That term,
enemy combatant, its definition shifted. The debate continues. What does that tell us about our ability to clearly define who's an enemy and who's a citizen when those lines get blurry in modern conflicts?
Right. In these long, unconventional conflicts without clear end dates, how do we stop that balance between security and freedom from just becoming, well, whatever the current threat seems to demand? Is it a fixed point or a constantly moving target?
Something definitely worth thinking about. Thanks for joining us on the Deep Dive.